In there, it said he distributed a seditious publication where he says, "Down with the enemies of the people, the exploiters of the weak, and oppressors of the poor. The days of those who have enriched themselves at the expense of the poor are numbered. The common man in Nigeria can today no longer be fooled by sweet talk at election time, only to be exploited and treated like death after the booty of office has been shared among the politicians." This appears at pages 3 and 5. He was charged, and what was the conclusion of the court? My Lord Justice Ademola, Chief Justice of Nigeria at that time, and that discharged Dr. Chike Obi in holding that it is a wrong interpretation of the law of sedition, and it offends the provisions of the section 39, which was 33 at that time of the law. Now, I took this case. During the last regime, the governor of Jigawa State took a young boy who went on internet and wrote several things. He wrote several things, insulted Governor Sule Lamido, and said he called him pastor, Alhaji, imam, and that he has manipulated the result of the election. And the young man was arrested. His father was arrested. They were put in jail, and they were tried before a magistrate court for the law of sedition. And the family took a lawyer. Unfortunately, they went to the federal court. The federal court could not agree with them and says what they did was wrong. The boy was granted bail in the military, and he ran away. So what I did when I was briefed was to go to the ECOWAS court. And the ECOWAS court, in 2011, it is reported in the report now held that what he did, it is normal. And it is within the law of the country under the constitution to say it. And this is why I want us to look at it. This is what, in the case of State and Uwakwo, 1985, 6 NCLR 228, which is not contained here, I want to say what my Lord Justice Olataura said. Those who occupy sensitive posts must be prepared to face public criticisms in respect of their office, so as to ensure that they are accountable to the electorate. They should not be made to feel they live in any ivory tower and therefore belong to a different class. They must develop thick skin and, where possible, plug their hairs with cotton wool. If they feel too sensitive or irascible, they are within their constitutional rights to sue for defamation. But they should not use the machinery of government to invoke criminal proceedings to gag their opponents, as the freedom of speech guaranteed will be meaningless. So, this is what my Lord Justice Nwako said there. Now, and several other cases which I don't want to belabor you with say that. Now, that is an aspect quite clearly that protects the citizens, that we should not misuse, that the government should not misuse those exception clauses or exclusive clauses in the Constitution. Now, on the other part, what do we look at? How do we maintain public safety, public security, public order? I bring it to you that in Singapore is a country that was colonized by America and Britain at various times. Lee Kuan Yew, who is the first president when he became the president, took a lot of decisive steps towards muscling the power of the press. And what were his position? He said that he will not allow the Western press and Western idea to suppress the growth of Singapore and Singapore culture. And today, he was able to pick for every publication you say that seems to keep down the power of the state government in growing along with their culture is find a way of taking policies in reducing their steps and actions in order to ensure that Singapore will grow according to its own strength, because it was found that most of the seditious publications were being sponsored by Western body. So in the circumstance, my own conclusion is that the provisions of section 39(3) and section 45(1) of the Constitution has been misapplied seriously by the government, in the sense that the law of sedition, the social and cyber crime acts have been extended beyond the limitations that is provided for in the Constitution. On the other side, the citizens too, we have to be mindful that we have to grow at our own time and ensure that when you shout and when you speak, your speech does not touch your neighbor. Thank you.
Thank you very much, Mr. Jimo. Please, let's give him another resounding applause. Yes. Yeah, thank you for looking into the laws, both the case law and, of course, other jurisdictions on the issue of freedom of expression. It's noted that under the Constitution, freedom of expression is one of those rights that can be derogated, but only by law justifiable in a democratic society. And the content of what is justifiable in a democratic society has been enumerated by our courts. And of course, DPP, Shikobi and DPP and Wankwans and states one of those decisions. So let's move on now and invite, I don't know whether Mr. Asamba is online. Can the technical team confirm if Mr. Asamba is online? He's not. Then let's move on to Mr. Deji. Mr. Deji, you have 10 minutes. Please, let's welcome him with a round of applause.
Thank you very much, Leonard Silk. Just to appreciate David Daudu, our Oga, in the struggle, and also my lords present, and Leonard Silk, and lawyers present. When you speak at a gathering of lawyers, it's very difficult because you can't teach them the law because they already know it. You can't even quote cases because they are familiar with it. They've been taught everything that you can say. Just like I said at the MBA conference when I spoke in Ibadan, I said when you are interfacing with lawyers, the only thing you can do is just to speak from the heart, because they are learned people, so you can't teach them any new tricks. Well, I have gone through my Egbon's paper, Adegorua, SAN. I think he has touched on all the issues. And Leonard Silk that spoke before me, when he was just sitting down, I told him, I said, the cases I brought to analyze, you have already analyzed this, sir. So there is nothing else for me to analyze. But looking at Adegoroa's paper, going through it, I can see a practical approach in myself. I think all the aspects he spoke about, criminalization of free speech through cybercrime, and this idea of criminal defamation, which the police always charges people. I have been first-hand victims of all these charges. I have been charged severally. I've been charged under the Cybercrime Protection Act 2015, and I was remanded as well. I've been charged under the criminal defamation. I was remanded as well. So I'm a regular customer to these tricks. However, my appeal, for both the bench and the bar is that we should take a more pragmatic approach to protecting and safeguarding rule of law and constitutional democracy in our country. You see, the bench, our judges, just like we saw in the case of Ato Wanko and the state, and Chike Obi and DPP, we saw when our judges were courageous enough to protect, because the concept of the Constitution is to protect rights. Yes, rights are not absolute, as Leonard Silk has said, because there's always a caveat. Yes, you're entitled to freedom of speech. However, there are exceptions. For instance, public safety, public order, and all those exceptions listed in 39 sub 3 and 45. So now, when judges and lawyers, especially the MBA, public interest litigations by lawyers from the bar, the MBA itself, this was something we spoke extensively at the Spidal conference in Ibadan, on the need to defend the rights of those who are being attacked. If under the military, we had a situation where judges protected freedom of expression, how much more under a so-called democracy where we have a plethora of cases that have been decided in courts, at various high courts, where judges have jailed people for expressing their opinion on Facebook and on Twitter. And under the military, judges were courageous enough to prevent such things from happening. But if you look at the case in Kaduna, Governor El-Rufai has jailed almost everybody that is criticizing him. If you look at Katsina, it's the same thing. They have jailed almost everybody criticizing them. If you look at Adama, somebody was jailed for criticizing the president. So if under the military, if you look at that Ato Wanko's case and what the court said, that sedition is archaic. These are colonial laws that were brought by the colonial masters. We cannot continue to give life to them. Somebody has defamed you. Why will you use the police to arrest the person and you're a public official, for God's sake, in the 21st century? And if you, just like what the court also said in Chike and DPP, public officials, if you cannot handle the heat, then leave the kitchen. The essence of public office is that you will be subjected to scrutiny and criticism. So because as a private citizen, people insult me and call me all sorts of names on Twitter and on Facebook, and I don't get offended, because a critic should be ready to take criticism. And I will never get offended by it, because I count it all joy that people are able to insult me. So if you're a public official, like Nasiru El-Rufai, who was loud-mouthed when he was a critic, who was loud-mouthed when he was on the street protesting, but today you are just a governor. You are not even president of the country. You have become a lord unto yourself in Kaduna, that nobody can criticize you, nobody can tell you that you are wrong. So, and all over the world, look at the case of America, where the president is called all sorts of names. He never arrests anybody. Because in my view, it's an abuse of power when you are in office to use state institutions to arrest critics, to imprison them, to jail them, to put them on trial. And this is what our judges must do. Our judges must be courageous enough, especially in a so-called democracy, to say that the freedom of expression that has been guaranteed in the Constitution is protected. Because the idea behind it, if people have not, and in my view, I believe that the exception should be when maybe somebody is trying to lead an insurrection, and it's clear. When somebody is trying to overthrow the democratically elected government, and it's clear. Thank God that Oga just walked in. I've been a victim of his activity in the police. They just sit in offices, cook up charges against people because they don't like their faces. And these are people, just because you are against the government, these guys will sit down in their office, they prepare a charge against you, and they will take you to court. And they know that the case they are taking to court is not even worth charging to court. So, and we must learn to speak truth to power. And judges, because judges cannot grant interviews, they must express speaking truth to power through their judgments. Lawyers, members of the MBA, we must place the profession above private and public interest. If you look at that case that was analyzed in detail by what Justice Kayode Esho did in the case against Wole Soyinka, it is clear that every government that comes with an agenda. And once the judiciary, you can't say that they are removing Justice Onogen through an ex parte order. The man that removed Justice Onogen is not even a judge, for God's sake. That man is an office clerk. How can you remove a chief justice of Nigeria with an office clerk, for God's sake? They invaded the homes of judges in 2015 or 2016, and you thought that they were joking. And they continue to do it. So the judiciary must rise to the occasion. And because the judges will not go to court to institute actions against the government. So courageous lawyers like you and your colleagues must be the one to defend the right of freedom of expression in the country. You must be the one to defend the rights of civil liberty organizations in the country. You must protect the civic space so that it doesn't shrink further. Again, it's important to note that the civil rights movement in America, exemplary. If you look at what the Warren Court did in Justice Oputa's book, which I recommend for everybody, I will provide it maybe at a platform. I can even try and see if I can get a copy and circulate to everybody. Everybody needs to read the impacts of the Warren Court on jurisprudence, not just in America, but globally, the impacts of the court. For instance, peculiar cases will come before my lords, and peculiar cases will come. Clients will come to you as a lawyer and say, oh, I have been threatened by somebody because I made a Facebook post. For instance, if you look at what's the import of Section 39, it's not only saying freedom of expression is only limited to the person speaking it. Even the people receiving it, they have a right to receive information. So if government bans Twitter, it's a violation of freedom of expression. Because people can no longer receive, for instance, if I want to express myself on Facebook or on Twitter, and government has banned Twitter in Nigeria, my followers have been denied the enjoyment of freedom of expression. You know, and lawyers should, in the interest of justice and the interest of the country, go to court and make sure that actions are brought. Because judges will be in court. Judges cannot institute actions. Lawyers must institute actions. So it's a collective responsibility to protect the freedom of expression in our country. Channels, AIT, and everybody. I have 3 minutes more. Channels, AIT, and everybody have been victims of an overreaching, overstretching, tyrannical regime. You see, the danger of saying it cannot be done. If the civil rights movement did it, they ended segregation in America, they ended slave trade, they ended exploitation. Who says it cannot be done here? The situation in America was worse than what it currently is. Our judges are so... I listened to Justice Ejemba Eko at the MBA conference in Speeder. He spoke before me. And I felt the pain of the judiciary, because how can the Constitution has separated the arms of government. There is a clear separation of power. But one organ of government holds the judiciary to ransom. Holds the judiciary. So how can the judiciary enforce? Yes, the position of Egbon Adegorowa is amazing. He has dealt with all the issues. However, there are stringent external issues that is needed for implementation of his paper to work. And this is where the bar and the bench must come in. I believe that judicial activism, we must ensure that the spirit and letter of judicial activism, is re-engineered. If we look at the contributions of Gani Fahimi in this country, Gani Fahimi almost litigated on almost every key issue. Every key issue, Gani made sure that he went to court, and J.B. Daudu has done same. Olisagbakoba have done same. Mike Ozokome have done same on local standing and so many. So, as young lawyers, my appeal to you is to dare the unthinkable. Because at a point they were calling Gani busybody, a busybody. But because if not for Gani, there are so many areas of law that will not have anything or any precedent to say we can refer to. So be exceptional. Be exceptional as lawyers to protect. Rights are being abused in Kaduna. Rights are being abused here in Abuja. Rights, freedom of expression is being abused currently in Katsina, where people are arrested at will by the police because they made a Facebook post. In closing, I would like to close by appealing to you that position of government is very temporary. Though those who were here before have gone, and those who are here today will leave. My appeal is born out of the fact that we are all going to be victims of the laws we make. For instance, the lawmakers who drafted the Cybercrime Act 2015, some of them have been victims of it, the same act already today. Because how do you make a law and say that if anyone posts or shares something that they are liable? How? How does liability work? Thank God our guy is here. They charged me for cybercrime under the Cybercrime Act. They charged me and I was laughing when they were charging me, and I said, if I was telling them, how can you substantiate this? How? How? Because we must make laws that will outlive us, because we will also be victims of those laws. Thank you.
Please, let's give Deji a resounding applause, please. Thank you very much, Deji, for raising some of the salient issues. And as you are speaking, and then also what my Daniel brother said, I begin to ask the question: do you think, has the Cybercrime Act actually brought back the crime of sedition that was set aside by Nwankwo and Chikobi? Are we seeing a revisitation of that? Should offending opinions not be limited to the confines of civil law? Should criminal law be used as an instrument to clear somebody's character? Because sedition law is a character law. It's about protecting the reputation of a public officer. Should public resources, which is used to administer criminal law, be used to deal with reputation law, such as character of a public officer? Shouldn't defamation be enough, or libel be enough to deal with offending publications that are not permitted by law? And these are some of the questions that are calling for answers, and I do hope that our participants, both those in the room and those listening online, should be able to respond during question and answer. There are also other legal regimes, statutes, which may not be mentioned in the paper, that impact on freedom of expression. Let's take in, for instance, the Nigerian Broadcasting Commission Act. This parastat NBC will slam fines on media houses for expressing opinions, whether those opinions are true or false. I remember that channel television, AIT, were all penalized for carrying information that's expressed by others. The media is there to relay information to citizens. So why should the Nigerian Broadcasting Commission Act be given such power to impose fine, which is a criminal sanction, without order of court? So these are some of the issues we need to look at. The Nigerian Communication Act, Communication Commission also has that power. They penalize, service providers, even the internet service providers, for what? Without a court order. Do they have the power to do so? Can administrative bodies such as that impose sanction, which is penal, without order of court? We also see the Prevention of Terrorism Act. If you look at the provision of Prevention of Terrorism Act, there are provisions restricting expression when the administrative person feels it influences terrorism, or influences the financing of terrorism. We see the Same-Sex Marriage Prohibition Act 2004, which provides that if you advocate for the right of sexual minority, you've committed an offense and can be sentenced to 14 years imprisonment. Even if no matter opinion held by anyone, democracy is about allowing people the freedom to hold opinion, to express it, to hold belief, and to express it. And when we begin to muzzle that window of expression, then we begin to attack democracy. But let us also know like I said earlier on, that freedom of expression is not absolute. It's also, it can be restricted within the law. On that note, let me invite, did I call him the elephant in the room? Or the second elephant in the room? Because I know Mr. Semba, a lot of people are waiting for you to come. At least as you know, this is a discussion group. This is a frank, informal discussion by lawyers. We're here to tell ourselves the truth. If you like, there is a shutdown room, shutdown house rules apply. So the expression made by Deji is a frank expression of trying to discuss the issue. We're all Nigerians, and this is a legal profession, so we must protect the law and protect the rule of law. So on that note, I want to invite the Assistant Commissioner of Police, Lo Esamba. You're not yet a senior advocate of Nigeria, I hope you know. Well, because if I call you senior advocate of Nigeria, they may send you a query, and on December 8th, you'll be asked to step aside. So, senior advocate designate, Lo Esamba, who is Assistant Commissioner of Police. You have 10 minutes. Please, let's welcome him with a round of applause.
May I first of all apologize for coming a bit late. It wasn't deliberate. And I also stand on the existing protocol already established. The topic of our discussion here, that is unlawful criminalization of freedom of expression. I will just go through the paper that I have here, and then which raises so many other issues in addition to the issues raised by the last speaker. Conceptually, freedom of expression, otherwise known as freedom of speech, is the right to seek, receive, and impart information and ideas of all kinds by any means. It could be by print, writing, internet, in fact, by any means. The origin of human rights. It is believed that freedom of expression started in the Athens, that is in the 5th century BC. Some are of the belief that it started from the Roman Empire, where the Roman Republic include freedom of speech and freedom of expression as their own principle of adjudication. In England, on the other hand, the Bill of Rights of 1689 legally established the constitutional right of freedom of speech in Parliament, which is still in effect and called parliamentary privileges. The Declaration of Rights of Man and the citizen adopted during the French Revolution of 1789 specifically affirmed freedom of speech as an inalienable right. The French Declaration provides freedom of expression in Article 11, which states that free communication of ideas and opinions is one of the most precious of the right of man. Every citizen may accordingly speak, write, and print with freedom, but shall be responsible for such abuses of his freedom. So there is a qualification there. Article 19 of the Universal Declaration of Human Rights, adopted in 1948, states every man has the right to freedom of opinion and expression. This right includes freedom to hold opinion without interference and to speak, receive, and impart information and ideas through any media and regardless of the frontiers. Today, freedom of speech or freedom of expression is recognized in international and regional human rights laws. The right is enshrined in Article 19 of International Convention on Civil and Political Rights, Article 10 of the European Convention on Human Rights, Article 13 of the American Convention on Human Rights, and Article 9 of the African Charter on Human and People's Rights. According to John Milton, freedom of speech or freedom of expression is understood as multifaceted right that include not only the right to express or disseminate information and ideas, but three further distinct aspects. One, the right to seek information and ideas, the right to receive information and ideas, and the right to impart information and ideas. International, regional, and national standards are also recognize that freedom of expression includes any medium, whether it is orally written or in print, through the internet or through art form. This means that the protection of freedom of expression as a right includes not only the content, but also the means of expression. In Nigeria, freedom of expression is provided in Section 39(1) of the 1999 Constitution as amended, which states that every person shall be entitled to freedom of expression, including freedom to hold opinion and receive and impart ideas and information without interference. However, Section 33(9), Subsection 3, qualifies this freedom of expression. It is obvious from the provisions of Section 39, Subsection 3 of the 1999 Constitution that freedom of expression is closely related to other rights and may be limited when it is in conflict with those other rights. Freedom of expression, as can be garnered from the 1999 Constitution as amended, is not absolute. Hence, most legal systems, including Nigeria, generally set limits on the freedom of expression, particularly when freedom of expression conflicts with other rights and protection, such as libel, slander, pornography, obscenity, biting words, and intellectual property. Some views, as we know, are illegal to express because it can cause harm to others. This category often includes speeches that are both false and dangerous. This category can lead to libel or slander suit, as well as criminal sanction in criminal defamation of character. Permit me to give a historical perspective of the law on criminal libel, punishment of slanders as provide criminal libel. Punishment for slanders was provided by the early common law through protection of those who maliciously spread false tales. Although it is not clear whether truth of the defamatory matter was regarded as a defense, it is certain that malice was conclusively presumed. The law of criminal libel, however, owes its origin not to the early common law, but rather to an innovation in Star Chamber, whereby elements of Roman law were employed as the basis for prosecuting the publishers of defamatory statements. Star Chamber reasoned that such defamation tended to cause breaches of the peace, since the tendency to provoke a breach of the peace was regarded as the gist of the crime. Whether the libel was true or false was considered immaterial. In fact, it was reportedly said that the greater the truth, the greater the libel. The statement being justified on the ground that persons whose fault had been exposed were more likely to assault the publisher that were the victims of the victor's accusation. Every libel is made either against a private person or against a magistrate or public person. If it is a private person, it deserves the severe punishment. For although the libel is made against one, yet it incites all those of same family, kindred, or society to revenge, and so tends by consequence to quarrel and breach of the peace, and may be the cause of shedding of blood and greater inconveniences. In the later part of the 17th century, following the abolition of Star Chamber, Jurisdiction over criminal libel devolves on the common law courts. The law requiring strict licensing of the press having been repealed. So you see, despite the fact that that is a criminal libel or criminal that is despite the fact that freedom of expression has over the years, that is from the beginning, been curtailed by so many other provisions. There are so many jurisdictions where the existence of that is criminal defamation have been abolished. I will give you an example of a few of them. That is, the present trend globally seems to tip towards abolition of criminal defamation, although a significant number of jurisdictions still retain the offense in their status books. So, among those that retain criminal libel in their books are Ghana, we have Nigeria, and then in Nigeria it is provided in so many of our laws. We have it in the Penal Code, Section 391 to 395 of the Penal Code. We also have it in the Criminal Code, Section 373 to 381 of the Penal Code. We also have it in the Cybercrime Act, as I stated earlier. We also have it in the Terrorism Prevention. So it is still provided in our laws. And that is why in the recent decision of the Supreme Court, in the case of Clement Aviomo versus Commissioner of Police, the issue that arose at the Supreme Court was whether Section 391, that is Section 391 to 395 of the Penal Code, was in conflict with Section 391, which make provision for freedom of expression. Even though the Supreme Court, by a unanimous decision, were of the view that so many other jurisdictions has abolished the law prohibiting freedom of expression, in our own jurisdiction, that has not been done. And until that is done, it still remains the law. So on the basis of that, the appeal filed by Lennes and Ezekuma was the one who was the other party, who was for the respondent. The matter started from the magistrate court in Wuse here down to the Supreme Court. So finally, the Supreme Court held that as far as our laws are concerned, criminal defamation still subsists, and until the National Assembly repeal those provisions in our laws dealing with criminal defamation, they still remain the law. So that is the current position. That judgment was delivered on the 12th of February 2021, that is this year. So that in Nigeria, as far as we are concerned, even though we have been agitating for the abolition of the law, it has not been done. So until that is done, it remains the law, and we will continue to suffer the injustice, just like what the last speaker has said. So our campaign now, what we are to be propagating now, is to abolish all those provisions, just like what other countries have done. We have so many examples. Lesotho, India, they have abolished all those ones in their laws. So until all those ones, that our National Assembly take up that challenge to abolish all those provisions in our law, we will continue to prosecute persons, or people will continue to lay direct criminal complaint on the basis of criminal defamation. So that is the current position of the law. So thank you very much for the opportunity given me to come and present this paper. Thank you very much.
Please, let's welcome the round of applause. Thank you very much, Mr. Asemba, for giving us a historic perspective, and then also being frank that there's a need to revisit those laws. So Mr. Asemba has thrown a challenge to us all, especially to Rule of Law Development Foundation, to initiate a bill, engage with our colleagues at National Assembly to abolish Section 391 to 395 of Penal Code Act, and also to repeal Section 50 and 51 of the Criminal Code Act, because these are the key provisions on criminal defamation. And also look at Cyber Crime Act. Even though he did answer Mr. Adeyanju's question about why should people charge him under Section 25 of Cyber Crime Act because he posted something on Facebook. I know those ones will come out in question and answer. Thank you very much for your insight. I also like your expression that the greater the truth, greater the libel. So I think that's very important that we should know that. But that should be confined within civil law, isn't it? So that the law of defamation will take its course during the libel proceedings. Now, happily, we've been informed that our lead presenter has designated a representative who will speak to his paper, Mr. Tosin Adesoye Esquire. Mr. Tosin Adesoye Esquire, if you're online, you have 20 minutes to speak to Mr. Adegoruwa's paper. You're welcome. Please go on.
Yes, ladies and gentlemen, good afternoon. I would like to apologize for my lateness to this event and the absence of my principal, Mr. Adegoruwa. He was unavoidably absent because he got caught up in some heated civil matters at the Court of Appeal, the ongoing chat meeting, and available for this wonderful conference. And diving straight to the topic, unlawful criminalization of the freedom of expression. I've been given a paper here prepared by Mr. Adegoruwa. And doing justice to this paper, I will start making an introductory remark. And the fact remains that in given times in Nigeria, there is social consciousness of the abuse of human rights. Now, one of these abuses is the clamp down on freedom of expression. And we have continued to receive pro and against arguments on why the Buhari-led government should continue to bring media laws to stop what we have as hate speech and false remarks. While on the other hand, people have come out to say, look, let us see between the truth and the lie. And by speaking about it, we'll be able to understand what is truly right and what is truly wrong. Going from there, what is the concept of freedom of expression? Yeah, I said the concept of freedom of expression is not unfamiliar in our jurisprudence. Freedom of expression is one of the fundamental rights which are universally recognized and protected. If we look at the 1999 Constitution, under Section 39, sub 1, it states every person shall be entitled to freedom of expression, including freedom to hold opinions and to receive and impart ideas and information without inference. Also go to Article 9 of the African Charter on Human and People's Rights. It states every individual shall have the right to express and disseminate his opinion. Finally, on Article 19 of the Universal Declaration on Human Rights, it provides that everyone has the right to freedom of opinion and expression. And this right includes freedom to hold opinion without inference and to seek and impart information and ideas through any media and regardless of any frontier. So, to summarize, what is freedom of expression? Jurists have said freedom of expression can be seen as the liberty to openly discuss issues without fear of restriction or restraint. And I must lay emphasis on the word without fear, because what we have now under this regime is, we are bold enough to express ourselves. We express ourselves with fear. We express ourselves knowing that the government can come on our heels one day, banging and breaking our doors, arresting us, inviting us, questioning our expression. So that's what I believe is the freedom of expression, to express your opinion without fear of restriction, of any punishment, of any restraints. And it goes to all other kinds of rights. Because in expressing your right, that's where you can have the right to fair hearing. In expressing your right, that's why you have the right to the kind of religion you want to have, the kind of opinion, the kind of ideas you want to have, and all other rights as guaranteed under Chapter 4 of the 1999 Constitution. The fact is this: without the freedom of expression, we cannot actually live as human. We cannot actually qualify ourselves as living with dignity and, expressing our rights to life. Now, going through, we have limitations against freedom of expression. It has been there from, the pre-colonial and even colonial areas. And that's where we can start with the offense of sedition. But before I go there, if you look at Section 39, Sub 3 of the 1999 Constitution, it is clear that indeed these rights, as stated by the previous speaker, indeed this right is qualified, the right to freedom of expression. But it's qualified to the extent that the right to freedom of expression can only be limited by a law that is reasonably justifiable in the country. So the question is, are the laws justifiable? If they are not, a court of law would pronounce on same, which we have had in recent time. So I said one of the first limitations here is the law of sedition. And that's where just previous speaker said Section 50 and Section 51 of the Criminal Code Act, which provides that any kind of hatred, any kind of contempt or dissatisfaction brought against either the president or the governor will be qualified as a seditious remark and, a felony under the law. These are ways our right to express ourselves, especially when we notice what is not right or what we feel what is affecting us does not curtail well with our conscience. These are the ways our right to express ourselves are clamped down on. Another law is the crime of defamation, which to me is possible because it's another reflection of civil tort of defamation. When we already have laws governing people's right to compensation if it turns out that someone has made defamatory remarks against you, I believe the provision of defamation in our criminal code, it's unnecessary and ought to be repealed. We still ever have it under Section 373 of the Criminal Code Act. Now, under Section 24 of the Cybercrime Act, the Cybercrime Act prohibits offensive, indecent, and annoying statements on the internet. It doesn't define what is offensive, indecent, and annoying. And so this is now subject to the enforcer of the law. And that is why we feel this kind of laws and section must be struck down, where it's ambiguous and continues to have different and multiple interpretation. It therefore should be interpreted as offensive to our right to express ourselves when it's not definite. Finally, we touched on conduct likely to cause public disorder. This particular offense has been waived like a magic wand. I will give an example. In 2016, a man was arrested in Otta for naming his dog Buhari and inscribing the name on the dog. He was arrested and charged with report for conduct likely to cause disorder. But under Section 249, naming of a dog is not among those conducts that can cause. I mean Section 249 of the Criminal Code Law of Ogun State, because that's what it was charged under. When you name a dog, such particular conduct is not defined under any law. That if I name my dog and I inscribe his name on it, I have caused or I'm likely to cause a disorderly conduct in the public. These are laws again that continue to limit people's right to express themselves. And the fact remains, we have continued to suffer under this present administration because there's now a renewed muzzling of freedom of expression. I'll start by looking at the Nigerian Broadcasting Commission's code. As we are aware, the NBC has continued to sanction several broadcasting stations that are continuing to publicize and report activities concerning either NSAS protest or like channel that was sanctioned. The interview with one of the dissenting people that belong to IPOB. And so the question still remains that should a media house be penalized with a code that doesn't have the backing of a law? Because for us, that code is not made by the National Assembly. That code, yes, was made in pursuant to an act. But does it have the backing of the law? And this is why we must continue to challenge, these draconian kind of codes. Finally, without taking much of our time, we must now look back and reflect on the effects of criminalizing freedom of expression. I stated that the 3 main losses suffered under the stifling of free speech are as follows. 1, an outright end of stoppage of information. The immediate effect of curtailing the aforesaid right is the end to all forms of opinion, all forms of idea, inspiration, and information. And so we have a state wherein we cannot disseminate the right truth, we cannot get the right fact anymore, and all forms of communication are closed. Yes, we know that fake and false and harmful expressions will be restricted. All other positive, innovative, and most especially true statements will be arrested by the law. Hence, the gains of criminalizing free speech will not be commensurate with the consequential loss of mankind improving solutions, ideas, and information. The outright ban of the operation of Twitter, for example, the micro-blogging platform in Nigeria, has laid evidence to this effect. People that do businesses on Twitter, people that have wonderful discussions, cannot communicate in Nigeria unless they have to download and use what we call VPN. Second, an important loss to our Nigerian democracy, where we continue to have the criminalization of freedom of speech and expression, is that we continue to reinforce a state of totalitarian dictatorship and totalitarianism. What do I mean by that? When we state for the fact people cannot express themselves, things that are not made under the law will become the law. So it won't become the rule of the law anymore to be the rule of the mighty. For example, on Monday, July 26th of July 2021, the Department of State Service supervised the media coverage of the trial of one Nnamdi Kanu, who is facing terrorism and treason felony charges at the Federal High Court in Abuja. And what they said was they can only allow a few accredited media houses into the courtroom. There's no such kind of law, there's no such kind of freedom to state that all persons to be restricted apart from few media houses that have been accredited. That is living in a state of dictatorship, whereby the dictators think what the law is and what not the law is. Furthermore, and on the final note, on another effect of criminalizing freedom of speech, the violation of all other basic human rights. Like I said earlier, the freedom of expression is the right on which other rights can be totally utilized and expressed. The end result of the limitation of the freedom of expression is the adverse interference of the enjoyment of other forms of human rights, whereby one is stripped of the enjoyment of other corollary rights, such as the right to freedom of thoughts, conscience, and religion. And the collapse of the freedom of expression, which is the foundation of the enforcement of all other rights, spells the beginning of the end to true humanity and purposefulness of living. There has never been an escape route, and between the role of the courts and the criminalization of freedom of expression. In the case of DPP versus Obi, reported in 1961, it was held that a court of law is not merely to rubber stamp the act of the legislature or the executive. Court must be the arbiter of whether or not any particular law is reasonably justifiable or not. So hence, it is the duty of the court as the state general to watch and ensure the protection of fundamental rights of citizens, and in appropriate cases guard the protection of the fundamental rights of the citizens. The judiciary is therefore the last resort empowered to strike down the statutory legislation instruments which negates and is not consistent with the limited circumstances whereby the freedom of expression can be derogated from. Now, an opportunity for the court to uphold the rule of law and secure the freedom of expression came up when a Katsina-born crusader, Mr. Shehu Mahidi, was arrested and incarcerated by the Nigerian police in December 2020 on account of his petition alleging corruption and misappropriation of over 52 billion worth of funds by the governor of Katsina State. In an application before the High Court by fundamental right, the High Court of the Federal Capital Territory found the Nigerian police force liable for the infringement of Mr. Mahidi's rights, and awarded the sum of 5 million naira against the police. Not ending there, in the case of Incorporated Trustees of Laws and Rights Awareness Initiative versus Nigeria, before the ECOWAS Court. The ECOWAS Court was faced with the legality of the provision of Section 24 of the Nigerian Cybercrime Act 2015. While the applicants had argued that the said provision of the Cybercrime Act had been used on various occasions in violation of their right to freedom of expression, the court noted that the African Court on Human and People's Rights has held that the term within the law must be interpreted about international norms which can provide grounds of limitation on freedom of expression. So the court held that Section 24 of the Cybercrime Act was a law that required three factors, which were: one, whether the provision of the law was clear and predictable, whether it pursued legitimate objectives, and whether the law was of a necessity and proportionate to achieve those objectives. In reaching its findings, the court opined that there was a strong precedent in Europe and in the Americas for the proposition that the criminal laws restricting freedom of expression should only be used as a last resort, and that restriction based on civil law was generally preferable. No, the court wasted no time in concluding that Section 24 of the Cybercrime Act violated the right to freedom of expression under both Article 9, Sub 2 of the African Charter rights. Similarly, the ECOWAS Court has recently found and recognized that access to Twitter as a medium for expression of the right to freedom of expression is guaranteed. In our concluding remarks, we stated that for a fact, things that have been held as against things that we have received in recent time, our freedom to express opinions that we've received in recent times, as our right to express in former days were not allowed. And for example, there was a time in the period of mankind where we as human beings could not come out to express our opinion about the earth, that the earth was circular. In those days, the earth was flat, and if you made any kind of further or adverse expression, you could be arrested and charged or a felony against the state. This is an example to show that, look, what we see today as an offense against laws that criminalize freedom of expression in later time can be seen as a right and not an offense. I will end with the Supreme Court judge's submission on the United States, Louis Brandel. He said those who won our independence believed that the final end of the state was to make men free to develop their faculties, and that in its government, the deliberative forces should prevail over the arbitrary. They value liberty both as an end and also as a means. They believe that freedom to think as you will and speak as you think are means indispensable to the discovery and spread of political truth. They recognize the risks to which all human institutions are subject to. But at the end, they knew that order cannot be secured merely through fear of punishment, and that it is hazardous to discourage thoughts, hopes, and any form of imagination. That fear breeds repression, and that repression breeds hate. That hate breeds menace against stable government. and that the remedy for evil counsel is good one. So I would comment in conclusion that let us allow freedom of expression, whether they want to call it hate speech. Hate speech is conquered by correct and right speech. People should be allowed to hear and receive and digest information from all angles, and from there they will receive the truth and throw away the wrong idea. That's my humble presentation. Thank you so much.
Thank you very much, Mr. Adesoye, for speaking through the paper, lead paper of Mr. Adegorowo. Please extend our regards to Leonard Silk. My Lord, Leonard Brother Silk, and Leonard friends, it is now time for us to ask questions, make comments. I know those online can also participate. They can either participate by raising their hands or sending questions through the chat box so it can be read out. Now, do I start from the room? Does anybody have any questions to any of the panelists or the presenter, or you just want to make a comment? But please, let's make it very briefly because we want to close the session on time. I'll give numbers. Can you raise up your hand? I'll give numbers. Number 1, number 2. Anybody from the inner chambers? You guys are in the inner room, in the inner bar. Number 3. I'm going to question all of you and not you. Stay in the inner bar. Who else here? Number 4. Okay, let's start with number 1. Then those online, please, anytime they raise their hand, let me know so we can give them opportunity. Please make your question or your comment very briefly. If it's a question, direct it to a particular discussant or the panelist.
Okay, I must start by thanking the presenters. I have a question.
Can you just say your name, identify yourself?
All right. My name is Ruben Kinya. I am a counsel in the chambers of Didi Dodo and Co. in Abuja. Now, I want to ask the ACP, the SN designate. Usually, the target of this freedom of information, the topic of discussion today, is the people, or are the people disseminating the information. They are the ones that the police will usually go after and prosecute eventually. What safeguard do you have for those who are entitled to receive such information, as Mr. Adeji Adeyanju has said? Example, Nigerians are entitled to know the health status of their president, and that information is not coming forth. Nigerians are entitled to know the information contained in declaration forms, especially declarations of assets, and those information are not being made public. And these are information that Nigerians need to have. Now, what are the safeguards, or what are the, what is the position of the law concerning the rights of Nigerians who are entitled to receive information by law? Secondly, the regulation of the FBI, to my opinion, is observed in breach rather than in I give an example recently where the governor of Kaduna State, who is highly reputed for violating people's right to freedom of information, traveled outside this country, made a post on Twitter against the policy of the government that he serves, came back to Nigeria, looked us in the eye, and said, well, he made the post not in Nigeria. It is the policy of this government, of the federal government, for instance, that no one or Nigerians should not engage in discussions on Twitter. But a governor of a state who understands the importance of passing information, went outside Nigeria to make a comment on Twitter. Secondly, I observed that the president, let me round off finally. I observed that each time the president of the Federal Republic of Nigeria wants to make a major policy comment or make any issue of national policy public, he goes outside Nigeria to make such statements. So what I'm saying is, regarding the prosecution of Nnamdi Kanu, he made such statements that, outside Nigeria, that he was broadcasting outside Nigeria, he was holding meetings outside Nigeria. He was arrested for those acts, while our public officers will still go outside Nigeria, make announcements and make decisions and make announcements, and nobody is saying anything. So what I'm saying is, my question is this freedom of information not observed much in breach rather than in compliance? Thank you.
Thank you very much. Number two, please, can you make your question or comment very brief so we can give opportunity to others to also speak?
Okay, sir. I'm Chris Balogun from the academia world. I'll just give you the summation of some of the findings of the research that was made in the universities. Sir, during the time of Jonathan, we demonized President Jonathan, insulted him, but Nigeria never collapsed nor burned. But the response by the protagonists of government, starting from the president at the apex, down to the governors and other stakeholders, I don't want to call name, is so appalling. Sir, freedom of expression reinforces human rights and societal development, growth and development all over the world. We all know that. And when you take it away, they said opposite is the case. It leads to decadence and the obedient stage of nature where life is nasty, brutish, and short. In Nigeria today, investigation reveals that as of 2019, to be precise, the date, April 19, that the life expectancy was 55. As of March 4th, 2021, it dropped to 54 years.
Please, sir, I meant to stop you. Are you asking a question or making a comment?
I'm making a comment, sir.
Please be very brief.
Okay.
Please, 1 minute.
1 minute. So, sir, the root cause of this crisis, 1979, they introduced the immunity clause of the executives. And when you look at every situation, the executives, they are too powerful. No matter your law, they can undermine it. So we are providing the solution that we have to look at the immunity clause of the, it should be reduced or removed. Legislation should be made on it. Then the autonomy and complete independence of the judiciary should be guaranteed. It's so unfortunate in Nigeria that we have more police, security operative posted to politicians of no value than the judiciary. That is just the solution. We should look critically at the immunity of the executive. They are too powerful, honestly. When they mention not only they can take life, sir, the research that they conducted, the killings at democratization at the democratic is more than the military. But because of the preference for democracy, people are not looking at it. Thank you very much, sir.
Please, can we know you? Can you introduce yourself?
My name is Chris Balogun. I'm from the university, sir.
Okay, thank you very much.
Yes, sir.
Number 3.
All right, sir. Thank you, sir. I am I.S. Yahaya. I'm from Kaduna State, so all of you have been bashing my governor since, but it's all right.
Are you from the Ministry of Justice, Kaduna State?
No, sir. I'm in private practice, sir.
Very well.
Yes. So mine is a question to the ACP Leonard Silk designate. I want to know what is the line drawn between freedom of expression and the national security. Because in 2018, President Buhari came to the NBA National Conference. In his opening remark, he told us that he will not sacrifice national security on the altar of freedom of expression or rule of law. So I want to know, how do the police come about, how do they define the line as between freedom of expression and national security. Let's know that, please. And then my comment is in response to what Mr. Deji said about the separation of powers within the three arms of government, which the Constitution clearly laid out. But that one arm of the government, which is the executive, had done everything perpetually to suppress the other arm, which the judiciary. I am of the view that the executive did not in itself suppress the judiciary, but the judiciary had made themselves an appendage or an extension of the executive. And so they seems to be oppressed. Where at one time in Kaduna State, they said they wanted to move all judiciary staff, all the staff under the judiciary arm to the Civil Service Commission. And they sat and watched the process going on. I spoke with some of them. Go to court by way of motion. Tell the court to give an order to stop this process. And let's see whether the court will not grant this order. But they sat and watched the whole process go through. Where Joseph went on strike so that the judiciary can be properly independent. But in the midst of the strike, the people that they were fighting for were they giving decisions and delivering judgments that they say that they are time-bound and they are sui generis. So it becomes difficult for you to say that the executive are actually the one who is suppressing the judiciary, rather than saying that the judiciary had made themselves subject to the executive instead of being totally independent. Thank you, sir.
Thank you very much. Is there anyone asking question online? Is there any question online? Okay. Please, if there isn't, let's draw my attention. Number 4. Who is number 4? Okay.
Thank you, Mr. Chairman. My name is Umar Farouk Abdelatif, the counsel at Nigerian Chambers, Kano. I observed that virtually all the speakers, while making their presentation, were placing much weight on the preservation of freedom of expression. I have a contrary view. And my view is that we should look at the rate at which the social media is being abused. This is a fact. I am a witness to a particular ongoing at the local government in Kano, Magistrate Court, was defamed, instead of being called a witch. And this was made on the fifth title that her name is Rama. And the author of that said, please stay away from Rama. She is a witch. Now my question is, should we allow the fact that we are making presentations, arguments on the preservation of freedom of expression, does that mean that we should close our eyes from the dirty things people do on Facebook, on media platforms, and the others? So what are the implications of doing that? Why we are talking about preservation of these rights, preservation of right to impart ideas and rest, we should also look at the other side of it. The morality, how it has affected the morality of the society. Should we just give people the license to do anything on social media? That's my question. Thank you, sir.
Thank you very much. Okay, let's take, yes, please. Let's take another round. Please.
Thank you. Straight up, let me ask. This is.
Please, can you introduce yourself?
Oh, my name is Osama Iswara, and I'm aware that this is judicial development updates and all that, and I'm not sure that I'll run into the SAN designate next if he leaves now. I'm asking, in connection with the recent Police Act. It's full of all those wonderful things about how the police will now start becoming person-friendly, use restorative justice, medium, and all of that. Please, Mr. Lau, can you let us know what in fact is happening in terms of updates on training of police to be more citizen-centered? I just thought I'd throw that in. Thank you.
Thank you very much. Yes. Any question online? No. Yes, any other question or comment before we throw back the microphone to the panelists? Okay. So, Mr. Asemba, I think you have most of the shots. I saw you are trying to dodge them as we are shooting you, but you can't run away from that. So, please, can you just respond to some of the questions as much as you can?
Thank you, Mr. Chairman. All other protocols observed. I will start with the last question, which Mrs. or Madam Ezora asked, whether the police is doing something concerned, doing or training our personnel to ensure that we are people friendly. I would say that a lot is being done. So the new thinking of the force is to deviate from the old ways of enforcement. Early this year, we senior officers were sent on course. And the theme of our course was building trust, making sure that the Nigerians we serve build trust in us. So, and that has been the theme. So you will discover that so many people are on course currently, and the paradigm shift now is how to build trust in the people we serve. If we don't build trust in them, there's no way we will serve them properly. So a lot is being done currently. People are on course in so many places, so many police colleges, and even workshops have been organized to change, that is the perception, the old perception of policing to a new perception of people-friendly policing. I also benefit from that. And some of my friends here, they also attended our graduation ceremony. With respect to I.S. Yahaya, who asked whether there's a thin line drawn between human rights and national security. It's not just a thin line, it's a wide line. You will observe that when national security is involved, everybody is involved. For instance, let me give the example of Mr. Showore. You know, Showore one time came out urging people to come up and, or let's say incited people to come out. You know, that ways, even though he has the right to say whatever he wants, you see, it has the implication of affecting so many people. In the process, so many people will die innocently. So many people were injured because people always take advantage of events. So people's properties will be destroyed. So that is why, even though people have the right to say what they want to do, they have to express their opinion, it is limited. That is why the Constitution itself, you see that section 39 subsection 1 has even been qualified by section 39 subsection 3. That's even apart from section 45. So section 39 has also been qualified itself because the drafters of the law understand the implications of making provisions allowing people to freely express. That is why it qualifies those provisions. So national security, especially when it is involved, it affects everybody. It affects the freedom of people. It affects the security of everybody. That is why it is taken very seriously. Those are the reasons why you may hear the president say, when national security comes to play, the right of citizen is second. And even in our court, there are so many decisions of the court which are clearly to that effect. If we see the case of Asaru Dokubo, the Supreme Court held that where national security is involved, the issue of human rights of a citizen is becomes second place. You know, because it's an individual that's involved here against the collective will of the people, and even the effect on the collective existence of the people. So those are the reasons why human rights come of an individual. It becomes secondary when national security is involved. And the first question was, what in the enforcement of that is provisions that a sort of curtail freedom of expression, what safeguard do we have to protect the receivers of those information? You will observe that before most of these informations or come to the law enforcement agent, they have already been said. Because before we come in, there must be a statement before we even come in. So it has become very difficult for you to even safeguard the interests of the people who are going to receive, because you don't know who are the people who are first of all coming to make those statements. So until they are made, and when they are made and they are reported, we don't just take them who can sing. We have to look at them, scrutinize them, whether they even merit prosecution. That is why you discover that there are just very few cases of criminal defamation in our court. Very, very few. You know, personally, I've handled just 2 of them. That is the one that we went up to the Supreme Court, and then there's one that is currently ongoing. So so you discover that the cases of criminal defamation are very few because they are normally scrutinized. Not that when you just write a direct criminal complaint complaining of criminal defamation, then we jump into prosecution, you know. So, and most of these our laws, as I earlier said, until they are amended, they remain the law. So we will continue to enforce. Our duty is to enforce. So where there are complaints and you examine them and you discover that there are merit in the complaint, certainly you have to go ahead to enforce the law. So I don't know whether I was able to, you know, I think I was able to take all the questions. So thank you very much.
Please, let's give an online participant opportunity to ask questions. Someone is raising his hand online. Please, can you ask your question, make your comment? Are you still online?
Yes, I am.
Okay, please go on with your question.
Good day. My name is David Stephen. Please, my comment is in respect of the dichotomy that was trying to be created between curtailing freedom of expression on the grounds that there is a vast abuse of that freedom on online platforms. First of all, as the panelists have already stated, there are civil remedies for anyone who makes any defamatory statement against a person. And if that statement is found to be false, there are punishments both in civil law and in criminal law. Now, that is enough deterrent for anyone to go on social media to make defamatory statement or lie against another person. I think even as legal practitioners, we tend to, most especially in the North, we tend to try to marry religion, morality, and law. Not understanding the fact that these 3 factors are separate from each other. freedom of expression is freedom of expression. You cannot curtail the freedom of an expression of a person who has not yet made any defamatory statement on the grounds that 2 or 3 others outside there are making defamatory statements. And so, if those people are found to have made defamatory statements, they should be punished, or whoever is being lied against should take them to court. That's why the courts are there. And so we should not be saying, okay, the instance of Twitter being brought down, and a lot of statements have been surrounded that Twitter took down the statement, a tweet written by the president, and that was the grounds on which Twitter was suspended in Nigeria. Now, it has infringed on the rights of several Nigerians, most especially those who make use of Twitter to earn a living, and this is not right. So I feel that freedom of expression should be curtailed, and it should not be sacrificed simply because there are some scrupulous persons online making comments that are immoral. Thank you.
Thank you very much, Mr. David. I would like Mr. Jimo to also respond to some of the questions, especially the one referring to the implication of abuses in the social media.
Well, my Lord, Mr. Chairman, before responding to that, there is something I noticed I observed from the various comments we are making. I see there is a difference between the power of investigation and the power of prosecution within the present state of our law. The administration of criminal justice law or act are specifically now giving power of prosecution to the Attorney General and the Ministry of Justice, no more the police. And when those questions were bombarded to my brother to the left, I looked at again. I went back to DPP and OB, and I want to read the opinion or the decisions of the Supreme Court. This is what they said. The extent to which prosecutions for seditions are brought is a matter for the Director of Public Prosecution, without whose consent under subsection 2 of section 52 of the Criminal Code, no prosecution for sedition can be instituted. The tenure of office of this official is secured by section 145 of the Constitution of the Federation of Nigeria, and subsection 6 of section 97 of the Constitution, which provides that in the exercise of his powers, the director shall not be subject to the direction or control of any other person or authority. Looking at these provisions, currently it is now section 150 and 174 for the Attorney General of the Federation. It is now 195 and 211 for the State Attorney General. I think if we want to effectively apply our law, the police rights to molest, violate, breach fundamental rights can be curtailed where we have effective and performing or practical oriented Attorney General heading a ministry, where when they pass the law, the era where police can just go and file cases, in my view, is gone. So I think we should look at that critically. Now, coming to the question, I look and keep looking at section 39 sub 3 as well as section 45 sub 1, because that's the focus. That should be our focal point at this Rule of Law Development Foundation conference. Section 39 sub 3, if we look at it critically, says nothing in this section shall invalidate any law that is reasonably justifiable in a democratic society for the purpose of preventing the disclosure of information received in confidence. So he did not make it general. The restriction has been misused, and the restriction here is only limited to for the purpose of preventing the disclosure of information received in confidence. Then the other ones, maintaining the authority and independence of the court or regulating telephony wireless broadcasting. Then section 45(1) says Nothing in sections 37, 38, 39, 40, and 41 of this constitution shall invalidate any law that is reasonably justifiable in a democratic society in the interest of defense, public safety, public order, public morality, or public health. Who determines interest of defense, public safety, public order, public morality, or public health? It's no other person other than our courts. So I will urge us to look at it critically. And our laws have said it severally. When you have a statute that is taking away your rights, it will be looked at strictly. So I think the freedom of expression has been misused by government or many other people believing that they failing to determine who is what is that public safety, what is that public order, and all what not. Thank you.
Thank you very much. Mr. Doshe, do you have any comments, final comment to make? Can you spend 1 minute to make any final comment on behalf of Mr. Adegboruwa? Okay. Okay, ladies and gentlemen, I want to thank you all for this very inciting session. The point has been made that freedom of information, freedom of expression is fundamental, and that its restriction must be on condition that is justifiable in a democratic society. Of course, democracy is about rule of law and citizens' rights. So any derogation that is not justified on those grounds should be struck down. Of course, the issue of defense, safety, morality, health, and security are defined by the courts. I also want to point out the fact that it's been said, and of course, my apparently have made sure that Asari Dokubo and the Federal Republic of Nigeria held that national security overrules human rights. But that is not the decision in that case, because it's a matter about bail application of Mr. Dokubo. And the court said that bail is not a right. Rather, if the person applying for bail can pose a threat to national security, then it's a ground to deny him bail. That cannot be extended. And I've heard this argument many places that Asari Dokubo established that national security overrules human rights. That cannot be extended to say that a bail application can be equated with clear provisions of the Constitution on rights. So these debates still have to continue, but it is a challenge to all of us lawyers, especially young lawyers, to take up public interest cases, to interrogate some of these provisions. We can interrogate the ban on Twitter. Somebody has mentioned here that ban on Twitter infringes on people's right to even receive information, because Section 39 protects the rights of those who are imparting the information and also those who are receiving the information. We can go to court to ventilate some of these provisions. We can challenge Nigerian Broadcasting Commission code that creates offenses and penalizes people even without a court order. We can challenge Section 50, 51 and Section 259 of Criminal Code and Section 259 of Penal Code and have the court strike it down. Of course, I'm really surprised that the Supreme Court will say that a section is unconstitutional, but it says, until we wait for legislation to strike it down. Of course, once it is unconstitutional, it is unlawful. So when we talk about unlawful criminalization of freedom of expression, we're saying what are the provisions that limit freedom of expression that are contrary to the Constitution, because it is broad now. Once it is contrary to the Constitution, it becomes unlawful without more. And that is the point that needs to be made. I want to thank the Rule of Law Development Foundation for this very interesting conference. And I want to urge us all to take benefit of the remaining sessions to begin to enrich ourselves on the diverse issues of criminal law. Once again, thank you very much.
Let us give our panel a resounding round of applause. That brings an end to day 2's session. You will agree with me that it's about 2:35, and we kept our word that we would make sure we keep you within the scope of the time, and we even have extra time for you to relax, network, take pictures, and say hello to your new friends that you have met And if you have seen old ones, it's a chance for you to kind of fraternize. Because we have really, really gone through the gamut of a lot of discussion. I must first and foremost congratulate and thank the chairman for steering us through this very, 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 it's a controversial topic. And I like how the chairman made sure the tempers were frayed and he managed everything properly and got us to this point. Learned Silk, you're very grateful. We extend our gratitude at the Rule of Law Foundation. Learned Silk represented Learned Silk Ebunoluwa Adeborua, SAN. Some of us may know the reasons why he may not be able to have been here. I know the excuse you gave Tosin, no problem. We know what he's going through, and I want to tell him that we are definitely behind him and he should be strong. And in fact, what he's going through is not unrelated to the topic which we have talked about. So, Tosin, if you are there, thank you very much. You really acquitted your principal very well. Mr. Jimo SAN, how can we say thank you? You really, really dissected the paper of the Learned Silk very well and even gave your own perspective on several issues. Thank you for the clarification as well on the difference between powers of investigation and powers of prosecution. And I'm sure taking that forward will go a long way. As for the representative of the Nigerian police force, one of our own, one who we are very proud of, Assistant Commissioner of Police, Mr. Simon Asemba. Thank you very much. In a few weeks, we'll be calling you Learned Silk. And I want to thank you for taking out your time to pen down your thoughts on this area. And indeed, clarifying that indeed, the police is our friend. We get to the situation whereby, honestly, we'll get a better nation for this. Thank you for even coming here to even take our questions. As for DG was here with us, but he's still a student in the law school, and he has a lecture at 3 o'clock. So he asked me to convey his apologies, but he gave us a practical perspective of some of the issues, and really his contribution is well recognized by the foundation. So thank you everybody for today's session. It's just to inform you by way of announcement that we continue tomorrow at the same time, 9 o'clock. And as you can see, the foundation is a stickler for time. We will try. Yes, today we started a bit late, 15 minutes, but tomorrow we will start early because we have a session which is chaired by no other person than Ahmed Raji, SAN, and we have 2 judges who are giving us presentations on the aspect of electronic evidence. What are some of the updates in electronic evidence? And we have no other person than Honorable Justice Alaba Ajileye, the High Court judge of Kogi State, and I'm sure most of us must have seen his publications on electronic evidence. He will be here in the flesh to navigate us through electronic evidence. And my Lord, Honorable Justice Mashood Oredola, who has been with us, my Lord has been with us since the beginning. At least from tomorrow, we will hear officially from him what are his thoughts on electronic evidence. My Lord will be looking forward to hearing from you. And we have 2 SANs joining them, Paul Erokoro and ATK Inde. So you know that we have a very action-packed session. And later in the day, we will be discussing substantive evidence outside electronic evidence. So please, try and be here on time so that we can finish early today. Thank you all for your attention and for being a very, 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 very responsive and patient audience. I don't know if there are any more information from the organizers. I think your lunch will meet you at your point of need, as we did yesterday. So have a good day and God bless you all. Thank you.
Place of the boy child in the family and the larger society cannot diminish. The boy child in a typical lowly family is left to wallow in wants and where his needs cannot be met, as it is in most cases, he becomes criminally impressionable. The consequence of the lack of mentorship is that the boy child is exposed to negative thoughts and vices in the community. This situation is compounded by dominance of poverty and ignorance, which make the boy child susceptible to negative peer influence and
Photographer, please let us have a group photograph. The resource persons, please let us have a group photograph.
And most times, perpetrators are actually boys, the boy child. So that's why one of the reasons why this project is here.
In the community, the boy is exposed to a high level of sexual abuse, rape, and gender-based violence, especially driven by abuse of dangerous substances. Such a boy child develops into an easy and pliable instrument in the hands of self-centered politicians who put him to use in electoral violence.
When people are not, or the rural populace is not guaranteed right to free education and right to also participate in political activities and governance, we must then come in and play a role. Now, one of the best ways to do this also, again, is to catch them young. We discovered that there had been I won't say an undue emphasis. Naturally, people get very worried when something happens to the fairer sex. I don't refer to them as the weaker sex, because in most cases, women are indeed stronger than men.
The boy child who is trapped in that situation turns round to detest school, and the consequence is that he will become prevalent in the absence of mentorship and counseling. Even while in school, albeit reluctantly, the boy child indulges in cultism, thefts, and other petty crimes. Again, this is another consequence of peer influence. Apart from diminishing the boy child's potential transition to adulthood, he falls off the path that leads to future leadership positions. Instead of being a beneficiary of the alluring dividends of the socio-economic and political life, he degenerates into the class of wasted generations.
Where do men get this idea of violence towards women, toward things like rape and early disengagement of the girl child from her educational pursuits? So we find that you can trace these things to the activities of men, maybe older men, but before they get to that point, there must be a frame of mind. There must be a state of mind that influences that. So what we did was to say, well, if you can arrest this untoward development at a point, start by re-educating the boy child, start by ensuring that he places a different value or a higher value or premium on the girl child. It will get to a point where if you saturate the system properly, you will find that the boy child is no longer a danger to the girl child and is no longer a danger to himself.
The situation has become very precarious in the Federal Capital Territory, and it is created by the insurgency, particularly in parts of the northwest of Nigeria. There is therefore unjustified and frightening pressure, particularly in the suburb of the FCT. The migrating boys roam the streets and the blind alleys, engaging in untoward activities, and some of them constitute nuisance values. They are easily exposed to vices and risky options, which put paid to the choice of schooling or even engaging in decent means of living.
In the rural areas, there is less economic empowerment. Parents, the burden is placed on parents alone. And it gets to the point whereby, without any aid or assistance to them, they bear the brunt of their being in the rural areas more than those in the urban areas. Secondly, it is always better to take a bottoms-up approach. And thirdly, issue of funding. If there are limited funds, it's best to apply it to areas that are very apparently marginalized and deprived. Right now, the funding is being done exclusively and solely by the Rule of Law Development Foundation, which gets its own funding from what we do in the legal profession. So it is from the chambers of J.B. Daudu and Co. Whatever comes to the principal partner, that is what he invests in this. So it is like a corporate social responsibility. If people come in to ask us for cooperation and the blueprint for this, we'll be glad to share it because it's something that helps and assists humanity.
When the choices are available, some of them take up hawking, even with the risk associated with it. There is the urgent need to reverse this dangerous trend, and that is what Project Hope for the Boy Child is conceptualized to address. ROLDF started to work on the pilot of Project Hope for the Boy Child in April 2021. The project is an inspiration. It is a deep understanding of the sociological context, the environment, and the psychosocial background which shape and mold the boy child. The ROLDF understands this very clearly. The organization understands that the boy child who is a victim of such denial and abandonment is emotionally unstable, and the communal discipline means nothing to him. What then is Project Hope for the Boy Child? Project Hope for the Boy Child, PHFBC, the brainchild of the ROLDF, is a comprehensive, age-appropriate, rights-based, youth-friendly, and gender-approach intervention that guarantees the safety, well-being, and economic future of young boys as major perpetrators of most acts of violence.
Project Hope for the Boy Child, as the name implies, is a project or an intervention targeted at the boy child to help them, because the boys have actually been left behind out of a lot of interventions from civil societies and from organizations, agencies, and donors. Why? Because girls are seen as more vulnerable in the society.
In conceptualizing the program, we try to think of, because every time you talk about the girl child, there are a lot of activities. And so we look at the boy child who returns from school from age 9. Our catchment group is from age 9 to 17. And they return from school and they go and play football and look for other things to do. And it is said that the idle mind is the devil's workshop. Now, if the idle mind is the devil's workshop, then there is a need to keep them busy and occupied. Busy and occupied, so we said, look, why don't we think of looking at the deepest rural areas and then find vocations for them so that they can learn professions.
The project is building capacity of young boys for economic stability through skills acquisition, while also providing a reorientation through facilitated discussions on broad topics such as human rights, toxic masculinity, sexual and gender-based violence awareness and prevention, harmful practices, financial literacy, decision-making, and consequences, as well as peace and nation building. The Children Act 38 of 2005 states in its preamble, and I quote, "It is necessary to effect changes to existing laws relating to children in order to afford them the necessary protection and assistance so that they can fully assume their responsibilities within the community, as well as that the child, for the full and harmonized development of his or her personality, growing up in a family environment and in an atmosphere of happiness, love, and understanding. Essentially, the new Children's Act seeks to fundamentally transform the nature and provision of services to children, to protect them from harm caused by exploitation, neglect, and abuse, as well as to promote the right to survive, to be safe, to belong, and develop. With regards to the boy child, the aims translate to the creation of an enabling environment, prevention of abuse and neglect, reduction of risky behavior in young boys and school dropouts. It also translates to the strengthening and development of community structures and resources that can help in providing care for them. These goals, according to facilitators of the Project's Hope for the Boy Child, are realistic through deliberate effort at empowerment of the boy child. At the pilot stage, ROLDF targets 100 boy children aged between 10 and 16 years from poor select communities from the Abuja Municipal Area Council in the Federal Capital Territory, FCT. The communities are Waru, Kabusa, Kurudu, Kuchingoro, and Karo Majiji. Vocational centers are being built in each of the 5 select communities. The ROLDF says the aim is to assist the boys acquire and develop economic and life skills that can help in improving their living